Thank you. All right, the next case on the docket is Ferguson versus State.
Good morning, Your Honors. May it please the Court, my name is Bruce Zimmett. Judge, I would ask for 5 minutes for rebuttal. I was not the trial attorney in this case. The issue before the Court initially is the issue of whether or not the trial court erred in denying the motion to suppress evidence based on the violation of the Almeida case. This is a case where the defendant was arrested in Virginia based on an affidavit and complaint from Orange County for several counts of sexual assault. He went to his initial appearance, asked for a court-appointed attorney, was denied the court-appointed attorney supposedly based upon the fact he made too much money. He went back to the jail. In the jail, several hours later, detectives from Central Florida came up, introduced themselves to him, and he made the statement, "Is this the time I'm supposed to have a lawyer?" Now, under Almeida, at that point,
Right, well, you would agree that's not a clear invocation of his, of a request for a lawyer.
right, and that's not the issue that he's requesting a lawyer.
So the issue becomes whether law enforcement had some obligation to respond to that
Right, and
question about his rights.
that's correct. And the Supreme Court in Almeida said that absolutely they do have a requirement to respond immediately. Now, there's some issue as to what the response needs to be, and the subsequent case of Glatzbeyer said that the law enforcement should not be in position of giving legal advice.
Well, when you say immediately, are you suggesting that no intervening time can pass and still comply with the spirit of Almeida?
Well, they need to stop everything.
Does it depend on what happened before they respond?
As far as what happened,
Before the police respond to the question?
well, no, the question needs to be responded to as it is the next thing that needs to happen in the interaction between the officers and the defendant is for them to give an answer to that question.
Well, I guess what I'm trying to understand is it simply a matter of time? For example, if your client said, "Is this the time I need to get a lawyer?" and the uncertain how to answer that question, the detectives say, "We're going to have to think about that," and leave the room for an hour. An hour later, they come back and say, "You have the right to an attorney," yada, yada, yada. Is the fact that an hour elapsed, nothing happened in that hour, but an hour elapsed between when he asked the question and when they answered it, or is it important what happened during the period of time, or is it both?
Judge, I think it's reasonable to be both, but certainly it depends on the circumstances. In the example the court gave, nothing happened during that hour period that would be other than the officers thinking about what their answer would be and then giving an answer. So there's no coercive effect. I mean, the whole rationale for Almeida is described in the case itself, and that's to stop the coercive nature of the interaction to begin with and get an answer to that question, whatever the answer might be.
What if what had occurred was simply that the people introduced themselves before they answered the question? I'm Detective Cohen from the sheriff's office, and this is Detective Orfinger, and nice to meet you, and then they go from there.
Well, it depends what the go from there is. If it's just an introductory of individuals, there's nothing coercive that's taken effect. And at that point, they would need to answer the question.
Okay, but here they used interrogation techniques.
Absolutely, and admitted interrogation techniques that were used. And certainly, whether they're appropriate or not really isn't the issue. The issue is under these circumstances, are they appropriate? And they're violative of Almeida because Almeida says you need to respond, answer to the question, and then once that's answered and responded to, and then you can go ahead and proceed.
Is this exactly what Almeida was designed to prohibit?
Absolutely. And from the standpoint of what happened in this case, the coercive nature and certainly the techniques that were used, and you can see as the detectives proceed, they followed the game plan they described at trial in the trial testimony.
What incriminating evidence was obtained from that statement?
Well, he gave, I guess the best description would be a false exculpatory statement. He claimed that he, quote, didn't remember having the sexual intercourse with his 9-year-old daughter. And the closing argument is replete with references that there's no way you can't remember something like that, and that answer is a false answer. And then in the detective's testimony, it was brought out by the state that in fact that he was crying during the interview, he was remorseful, and he made admissions as to his wrongdoing during the course of the interview. So the fruits of the interview were brought out, not only the interview itself as to those aspects, but also the detective was able to reinforce it and became a feature of the closing argument that this is part of his lying about not wanting to admit what he did, and this is a way of lying about it, and that proves his guilt. And that was really a predominant aspect of not only the opening closing argument, but also the rebuttal closing argument on behalf of the state.
All right, let's talk a little bit about the testimony of the brother-in-law. Why is that preserved either below or here on appeal?
Well, obviously I wasn't the trial counsel. On the motion,
You are appellate counsel, and did you raise that in your initial brief?
the issue was raised.
Whether it was fundamental error. You've claimed that it was preserved, and I don't know how you conclude that. Because,
It was raised in the motion for new trial.
right, but that's not, the whole purpose, you have a motion limiting, and then you have a motion for a new trial. And I don't think either in this context are sufficient to support a contemporaneous objection, because the motion in limine, it appears that the prosecutor might have misrepresented to the court the nature of the testimony from the brother-in-law. And so the judge is ruling upon what's in front of him at that moment. And so he makes a pretrial ruling. But then once the trial starts and the testimony starts coming up, it's quite clear that that's not what he's going to say. He's going to say, this guy's a pedophile. Why wouldn't there be an obligation for a contemporaneous objection?
Well, I think there should have been
I think that there has to be, is my point. To preserve that issue, you have to object to
But
it.
the question is it sufficient to allow, and the whole purpose of the contemporaneous objection rule is so the trial court can make a ruling at that time. I think the issue is if it's not raised at trial, but raised in a motion for a new trial, so the trial court has an ability to at least digest the issue, make a ruling on the issue.
Any case law to support that contention?
I don't have a case law, Judge, okay, to support that.
Let's assume that the case law is contrary to that the case law requires you to have a contemporaneous objection to preserve that evidentiary issue. Then the issue would be whether it was fundamental error.
Correct.
Did you raise fundamental error?
It wasn't raised as that based on the belief that raising the motion for new trial has sufficiently raised it in the trial court.
And if we disagree with that and you haven't raised fundamental error in your initial brief, then it's not preserved for us for appeal either, is it?
It's not preserved. Well, I would still argue, even though I don't have the case law to support it, that the fact that it was raised in the motion for new trial did preserve it sufficiently to raise it on the appeal as it was raised in the initial brief.
But even as your motion for new trial would have to be a fundamental error argument, wouldn't it?
It probably should have been. It wasn't. But it certainly doesn't mean that the issue wasn't raised properly on the initial brief.
Okay, then now take a couple minutes and talk about the comments by the detectives in terms of your lying and that type of thing.
The detectives, as part of the interrogation, would ask Ferguson or say to Ferguson, we know you're not telling the truth. We believe what the victim is saying. And we've done the research, we've done our investigation. In fact, she is telling the truth. Under those circumstances, that's testimony of the detectives, which is opinion testimony, which should not be part of a statement that is given or received by the jury. It's improper opinion testimony. Their opinion, whether someone is telling the truth or not telling the truth, is not admissible testimony.
This wasn't a situation where you needed the detective's comments to give context to the defendant's answers, was it?
I don't think so. I think they can confront the defendant, okay, and question them without giving their particular opinion.
How was the issue of the detective's expression of guilt preserved for appeal?
Well, I think the specific objection was not made at trial. It was made as part of the motion to exclude the entire testimony based upon the Almeida violation, and would have had the entire statement not included.
Right. I understand your argument is it shouldn't have come in at all, but assuming that some part of it is admissible, the specific objection to the detective's expression of the defendant's guilt was never teed up for the trial judge, was it?
Correct.
Right now, you're into your rebuttal time if you'd like to pause at this point.
I will, Judge. Thank you.
May it please the court, I'm Rebecca Wall, Assistant Attorney General representing the state.
Well, let's talk about the brother-in-law's testimony. How was that relevant to any issue in the case at all?
As Mr. Zimmett says, I was not the prosecutor below, and I would agree that the testimony as it came out turned out not to be relevant. I don't know that the state necessarily misrepresented what they knew the testimony would be. I think the state, in good faith, told the judge that the witness would testify to observations about the interaction between the victims and the defendant.
Okay, so let's give the state the benefit of the doubt for a minute and say, all right, so when the brother-in-law says, I thought the guy was a child molester, that was unexpected, but there's a good follow-up then. And the follow-up, the prosecutor, of course, instead of saying, oh my goodness, says, why did you think he was a pedophile? I mean, doesn't that add to the problem? I mean, I agree it's not preserved, but it seems pretty bad to me.
I'll say that in the more than 20 years that I've been doing this, I've seen probably hundreds of situations where I thought I certainly would have presented evidence differently, and I'm sure every member of the panel has seen cases where they would have ruled different than the trial judge.
To put somebody on the stand to testify that somebody was a pedophile in a lewd act or sexual battery case, I mean, you know, these prosecutors are specially trained to handle these types of cases. This is just unfathomable. I don't understand how it could possibly occur.
And I don't disagree with you, Judge Cohen, but the fact remains there was no objection whatsoever to either the term child molester or pedophile.
Well, let's see, though, if you agree. In general, do you agree that the brother-in-law's testimony was irrelevant?
I agree.
And that the trial judge erred when maybe he erred innocently based upon either a misstatement, misrepresentation, misunderstanding of what the testimony was going to be, but ultimately it turned out to be irrelevant. And you also agree that the gratuitous statement that the guy was a child molester, followed up by the state's, and what made you think he was a pedophile question, you agree all that's out of bounds?
Absolutely agree with that.
And whether it's, you agree it's error, you agree it's unpreserved error, and I agree with Judge Cohen that it really wasn't teed up as a fundamental error question, but
I absolutely agree with the court. It was painful to read as the appellee, but the fact remains that it wasn't preserved, it wasn't raised as fundamental error.
Let's talk about the main issue in the case, the alleged Almeida violation. You know, we've got a relatively short period of time, 2.5 minutes, between the time the detectives say good morning and the time that they administer his Miranda warnings. And we've got the trial judge saying that he clearly asked a question that related to his right to counsel. but the trial court ruled that the delay and what occurred thereafter was trivial and insubstantial, which I'm not sure where that standard comes from. Do you have any idea where the trial judge gets that standard?
Well, I think the trial judge actually was applying the Almeida analysis, the two-prong analysis, one that required a showing that there was coercive police activity, and the second prong that coercive activity overcame the defendant's free will. I think if you look at the trial court's order, the court does that analysis.
Let me ask you this, then. In your brief, you make an issue of the fact that he had not been read his Miranda rights at that point in time. Let's assume, hypothetically, that he had been, that he had been read his rights, made that statement, questioning about his right to counsel, and then for 2.5 minutes, the detectives use techniques that they have been trained to use to overcome the will of a defendant and to make a defendant comfortable, so that the defendant will talk to them and will give them statements. Do you think in that context that would be improper if he had been warned of his rights?
What I hear in that question is assuming that the subjective intent of the police officers to cajole the defendant
Well, we know that to be true. We know that they were using techniques that were designed to make a defendant comfortable so that the defendant would make statements. That was absolutely the testimony in the case, that was what they were doing.
Well, I think the testimony showed that during the course of the interview they did. I don't know that applied to that first 2 minutes. Clearly, the first 2 minutes was the officers explaining why they were there. This defendant was arrested.
It was more than that. They were talking about, they've checked his background out, what a good guy he was, how, his family said all these good things about him. I mean, those are techniques that they are trained to use in order to get a defendant to make statements to them.
Well, assuming that applied to that first 2 minutes, the question then still is whether those tactics were coercive tactics and whether that coercion overcame the will of the defendant. Now, it's the judge went into detail.
So I'm getting back to my question. Assuming that they read him his Miranda rights, your position would be that that's okay to do what they did because it's not coercive?
No, that's not what I'm saying. If the scenario was different, if the officers had read him his rights and immediately upon telling him his rights, he said, "Is this where I get an attorney?"
That's hypothetical to you.
Right, and I think that would have been a totally different scenario, and that's not what happened.
So, all right, that's fine. So if he had been read his rights and then they did what they did for that 2.5 minutes, you would agree then that the statement would have to be suppressed?
I'm not agreeing to that, because I think that it's still a matter of whether what they said during those 2 minutes was coercive that overcame. I think the analysis is a two-prong analysis. And I think you have to determine whether or not that was coercive or just avoided answering the question right away. Almeida is...
You're not supposed to avoid answering the question right away.
Well, you're not supposed to avoid answering the question, but the mere fact that...
Did they ever answer the question other than reading him his rights?
I think reading the rights was exactly the right answer to that question.
There are other answers that could have been given.
Well, there are a number of things they could have said. The question is whether what they said overcame the defendant's, was coercive and overcame the defendant's free will.
What difference does it make if they had read him his Miranda rights first? If he's aware of his right to counsel and announces that to the detectives, why should it make a difference whether they read his Miranda rights before or after?
Well, when the defendant appeared for his first appearance and he asked about an attorney, I think it's clear he was asking for his Sixth Amendment right to an attorney to represent him at trial. There's no indication he was asking for his...
About that, I'm talking
Right.
about.
So the fact that he had mentioned lawyer at all doesn't necessarily indicate that he was invoking his Fifth Amendment right to counsel. He had talked...
Certainly was inquiring about his right to counsel during questioning, during questioning.
He mentioned, right, I mean, he clearly asked if this is the time I get a lawyer. And the immediate answer was, I'm going to explain that to you.
No, I will get back to you.
No, I'm going to go into that. I'm going to explain that to you. That's exactly what they said.
They take 2.5 minutes of using techniques that are designed to make a defendant feel
Comfortable.
so that he can,
Exactly.
so they can get statements.
To make a defendant
So what
comfortable.
coercion do you think is necessary? Do they have to hold him down and beat him?
Well, I think if they held him down and beat him, yes, that would be coercive. I think if they were aggressive towards him, I think there's any number of scenarios. The scenario we have is, it was if it was designed, I think the only testimony was...
So if they're nice, you can't have coercion? That's the key?
I think you can if it appears that the defendant is coerced by that. And the trial judge, in viewing the video, determined by the demeanor of the defendant and the demeanor of the interviewing officers that there was no coercion. So it's not clear to me whether the court has the video. I saw no indication that the video was actually here as part of the record on appeal. The trial judge did view the video, did get to see the demeanor of the officers, the demeanor of the defendant, and reached the conclusion, based on that, the totality of the interaction during that time, there was no coercive activity by the officers, and there was no overcoming of the defendant's free will.
State versus Glatzmeyer say if the police don't know how to answer the question, re-Mirandize them?
They did Mirandize him. So even if, right, exactly. And so even if they are unsure of what he's asking...
They waited 2.5 minutes to do that, and during that 2.5 minutes, they are employing techniques that they have been trained specifically to overcome an individual's reluctance to talk about these issues.
Well, that's their, sure, they admitted that they are trained to make a subject, whether it's a witness or any kind, comfortable.
Why isn't that coercive? It's designed to do exactly what Almeida tells them not to do, which is, you've been asked about, an individual inquires about his rights, answer the question. Don't start laying the predicate in using techniques to get a confession, which is what they did.
Well, I think it's clear that the whole intent of Almeida and the spirit of it, the force of Almeida is, you answer their question. They answered the question. The trial court found it was truthful, it was direct. The mere fact that they explained who they were, why they were there, the defendant was arrested in Virginia.
It was more than that, though. I mean, if that's all they did, I would be with you on this. If all they did was to say, I'm Detective so-and-so from, Florida. This is Detective so-and-so from Florida. We're here to talk to you about this circumstance, then I'm okay with you, but they went well beyond that.
Well, Judge, I think it sounds like the fact that they testified at some point during trial, that they're trained to, what they did with the defendant was no more than social skills as far as making the person you're talking to feel comfortable. Because they were trained to do that doesn't make it coercive. Yeah, they learned that if you bring a little sugar to it, you get a whole lot more out of the interview. That's their technique. A different officer might have done it differently. They did it that way. That doesn't mean that the defendant was coerced.
Take a little bit of time and talk about all of the statements by the detectives commenting upon the credibility of the defendant, calling him a liar during the statement.
Absolutely not preserved in any way, shape, or form.
Error?
I don't believe it was error, partly because when you look at the context of how it all occurred, and you look at the cases that talk about those instances where it's error. There's an analysis, there's some discussion about whether the statements of the police officers are part of the ongoing, are intended to elicit actual responses as opposed to, you did it, and the guy saying, I didn't do it, you did it, you did it, you did it, we know you did it, and just a badgering technique. I don't think that occurred here at all. More importantly, any error, even if the fundamental error was preserved and raised, even that was waived when defense counsel actively drafted the final version of this confession that was presented to the defendant, that was presented to the jury, went page by page. Everything the defense attorney wanted in was in, everything the defense attorney wanted out was out. No mention whatsoever of the police officers, their statements, or anything. This wasn't just passive acquiescence to what was presented. This was a conscious drafting of what the jury saw. So even fundamental error was waived in this particular, as to this issue.
You think with all of these errors, and brother-in-law's testimony and the Almeida issue, that this individual got a fair trial?
Absolutely. Both the victim and her sister testified specifically as to the event, the acts that occurred on them. The controlled call, even though it was highly redacted, to take out mostly anything that was prejudicial against the defendant, still included some references to acts, some consciousness of guilt by the defendant. He got a fair trial based, if nothing else, on the evidence of the victim and the Williams role witness. Thank you.
Thank you. You've got just under 4.5 minutes.
Thank you, Judge. Judge, as far as the brother-in-law issue goes, I would suggest to the court that this issue might fall within a very narrow type of case where the court could find on the record itself ineffective assistance of counsel for not raising the
But you
issue.
didn't raise that in your...
Excuse me?
You didn't raise that.
I understand, but nothing prevents the court from doing that. And I would suggest that, I think we all sit here in this room realizing it's something that should not have been presented, should not have been presented to this jury, and certainly was inflammatory and prejudicial, and should not have come in front of the jury. As far as the Almeida issue is concerned, and the facts, we've described the litany of things that were presented to Ferguson. Clearly, it was an attempt to satisfy the game plan, to get him to agree, to want to talk to them.
Did you think it was coercive, and if so, why?
It was coercive, I think, by its very nature. It's coercive because they're telling him all these things that want to make him talk to them, to think that these are good people here to help him. We've already done our research, or think we're a good guy. It will help you if you talk to us. And by that nature, in a jail cell, having not had counsel, thinking that these people are there to help him, that is inherently coercive, and inherently shows that he had a right, okay, to have that question answered without going through the litany of things which were done before his rights were presented to him.
Are you aware of any cases where the police truly answer the defendant or suspect's questions? I'm not talking about respond to. I mean, in Glatzmeyer they said, that's your call. That's not an answer, that's a response. Are you aware of any cases where the police truly answer the defendant's question?
I think at least the court is describing in Contreras, for instance, which came after, I keep mispronouncing Glatzmeyer, saying that that is a question that we can't answer, that's up to you, that's an answer to the question. I think there are certain cases which...
But Almeida says you have to answer the question.
Well, they're based on Glatzmeyer, which was interpreting Almeida, that was sufficient, and that was considered an answer. I think what Glatzmeyer says is that they don't have to give an opinion, a legal opinion, because the problem was making law enforcement give legal opinions in response to the answer. But it was sufficient to say that's a type of question, and usually it's based upon, do I need to get an attorney right now? And to answer that question, a law enforcement official would have to be giving legal advice. To say, I can't answer it, but it's an answer that you have to give yourself.
And Glatzmeyer says if you don't know what to say, give them the Miranda rights again.
Well, Glatzmeyer says that the I don't know, okay, answer is okay, and then Miranda rights is sufficient to advise them of what their rights are, and that's sufficient, but that constitutes an answer. It's not a non-answer, it's an answer. In this case, we don't have an answer because what's happening the time to me is irrelevant. It's what's said. I realize time can be an issue, but underlying with the 10 different things that are presented to him, clearly there's an attempt to get him to want to be talking to them.
And make any incriminating statements before he's given his Miranda rights by the Orange County deputies?
No. He
Is that
responds.
relevant at all? I mean, once he's coerced for the rest of time?
Well, he's coerced because they're engaging him and wanting to talk. They're telling him all these great things about him and why it's in his interest to talk to them. Once he's wanting to talk to them, then he's asked questions which are incriminatory. And obviously their purpose there is to get a confession from him. They're not there
It's their
to,
job.
well, there's nothing wrong with that,
Right.
okay? But in doing it, there's certain rules that you have to follow to get there. And in this case, those rules weren't followed.
If they had read him his Miranda rights before the 2.5 minutes of interrogation techniques, would they still have been barred from using any of the testimony, in your opinion?
If he had waived his Miranda rights and had not asked the question, then certainly those interrogation techniques would have been appropriate. The question is,
But if he had asked the question, Glatzmeyer says, if you don't really know how to answer the question, which from all the cases, the police really can't truly answer the question, if they give them the Miranda rights, Glatzmeyer says that's okay, and then if they'd engaged in that coercive technique after that, would that still have tainted the entire interview?
no, it would not have, because he would have satisfied Glatzmeyer, because he, if I understand the
Right.
example, asked the question, Miranda rights, then coercive tactics. That's fine.
So the sequence is of utmost importance.
Absolutely. Thank you.
Right.